Hi, I'm Steve Schindler.
I'm Katie Wilson-Milne.
Welcome to the Art Law Podcast, a monthly podcast exploring the places where art intersects with and interferes with the law.
And vice versa. The Art Law Podcast is sponsored by the law firm of Schindler, Cohen & Hochman, LLP, a premier litigation and art law boutique in New York City. Art Law Podcast listeners, as you may remember, Steve and I have covered on several occasions the controversy the Berkshire Museum, located in Pittsfield, Massachusetts, has been involved in regarding the deaccessioning of its most valuable works of art. The context of this controversy was that the Berkshire Museum, having fallen on hard times, as many institutions in post-industrial parts of America have, came up with what it called a new vision plan, by which it was going to raise tens of millions of dollars to revamp the museum, both physically and in terms of its mission. And it was going to raise this money in large part by selling off a substantial number of its most valuable works of art, many of which had been with the museum since its very beginning, and were by significant artists like Norman Rockwell and Alexander Calder. So we've covered this both from the beginning of the controversy through the settlement that occurred between the museum, the Massachusetts Attorney General, which by way of its regulation of Massachusetts nonprofits regulates the Berkshire Museum as well. And they settled this controversy with the approval of the Massachusetts Supreme Judicial Court, ultimately permitting these sales through Sotheby's with some restrictions. And so many people think, okay, well, the sales have happened, some may continue to happen, case closed. But one of the lawsuits that this controversy spawned is ongoing. So we're going to hear from one of the lawyers working on that case today.
We're lucky to have with us today an author and lawyer, Nick O'Donnell. So Nick, as some of our listeners know, we've been covering the controversy at the Berkshire Museum from our first episode, and you are the representative of one of the plaintiff groups, and there's been a recent development we thought we would ask you about it. Just tell us who you represent and what has recently happened.
Sure. So I represent three individuals who live in Berkshire County who are members, paid members of the Berkshire Museum. And on their behalf, we brought suit a little less than a year ago to enjoin the sale that had then been scheduled for November of 2017. And at the same time, there was the lawsuit brought by the Rockwell family and some other residents of Berkshire County. As your listeners no doubt know, that injunction was denied in November of last year. And at the same time, my client's lawsuit was dismissed. So we appealed that dismissal right away. The briefing on that appeal happened over the course of the winter, and then we've been waiting for an oral argument since. That oral argument happened Tuesday, September 4th.
Okay. And why was your lawsuit dismissed? What was the rationale for that decision?
The Superior Court, which is the trial court in Massachusetts, dismissed our claims, holding that my clients did not have standing to challenge the sale or the decision of the museum.
What does that mean just in general?
Sure. So it basically means that the standing is, for lack of a better phrase, ruling that you're the wrong person to complain about what's going on.
And your clients are, when you say they're members, it's as if I'm a member of the Metropolitan Museum of Art. I pay some money every year and I get some perks for that.
They have no voting rights.
There are no voting rights in the Articles of Incorporation or in the bylaws. One of the tensions that came up in the hearing, or one of our arguments anyways, which I note has been unsuccessful so far, is the bylaws. Well, put it this way. The museum argued that when you read the bylaws, that when it refers to members who have certain rights under Massachusetts law, they are limited, but members of a nonprofit have standing to sue a nonprofit corporation if it implicates their rights as members.
But doesn't that typically refer, I mean, I'm much more familiar with the New York case,
Sure.
But doesn't that refer to members, capital M, in terms of voting members who elect the board?
Typically it does. And the question that has arisen in this case, again, which has been thus far held against us, is when you read the bylaws, they use the terms in a not always consistent fashion. The museum argued that because the bylaws empower the trustees with all the powers of members, what that means is that the trustees and only the trustees are members with a capital M. What we pointed out, and one of the things on which we rely, is there are other places in the bylaws where the trustees are instructed that they have to become members and maintain a membership, which wouldn't make any sense if they were the same group of people because they would already be members by virtue of being trustees.
What are your clients seeking now that the Supreme Judicial Court of Massachusetts, as we know, has blessed the agreement between the Attorney General and the museum and has allowed sales to go forward up to $55 million in a complicated way? And some of those sales have been made. They haven't all been made. But assuming for a moment that your clients were allowed to proceed with their lawsuit, what is it that they're trying to get?
Situate us now in
Sure.
the timeline. We've talked to our listeners about this, but they may think this saga is over, so explain to them why it's not.
So the decision by the single justice of the Supreme Judicial Court last spring was a CPRE case, and it relaxed or modified the explicit restrictions on certain works of art and held that the museum could now sell them unencumbered by those restrictions. What we're seeking is a couple things. We still maintain in our original lawsuit pointed to those restrictions as one reason the objects should not be sold, but not as the only reason, because we alleged and argued that the sale, the deaccessioning more broadly, is an abuse of the trustee's fiduciary duty to the museum.
And that wasn't an issue dealt with.
And that was
by
not,
the
in our
Supreme
position, is that issue was not resolved by the SJC decision. The SJC decision says these enumerated restrictions are now gone, and thus those restrictions are not the obstacle to the sale, and obviously some of those sales have taken place. Our point is the broader context of this decision and what it does to the museum as originally devised as, in part, a significant art museum was inconsistent with the trustee's duty. And because we have brought the action in part derivatively on behalf of the corporation, we're not seeking any damages for our clients in their own right. Really what we're trying to do, in the same sense we were trying to do when the case started, is compel the trustees to account for this quote-unquote new vision, which now is even more pressing in the sense that there's obviously a significant amount of proceeds that's been recouped, and what that means in connection with the underlying mission of the institution, we feel like is still an unanswered question.
And is the AG, which is now, as our listeners may remember, realigned itself with the museum after the settlement
Yes.
in the CPRE proceeding was approved, what is their position, the museum and the...
So the Attorney General, after the settlement, filed a letter in our appeal in which the Attorney General was not a party. We did not sue the Attorney General, arguing that the Superior Court's decision should be affirmed because in the Attorney General's view, our clients lack standing, that the oversight of the nonprofit corporation in the Attorney General's view is the exclusive province of the AG, which is not quite so, and that there are exceptions to that, as everyone at the hearing acknowledged, and that the boundaries between those things is one of the things that's at issue. And the Attorney General at the hearing last week was allowed to present a brief oral argument and essentially made the same point.
So they're litigating a substantive issue on appeal, which is the standing issue, rather than just saying, this is totally moot, why are we even talking about this anymore?
Right. The Attorney General has said essentially, we are the ones with exclusive standing. We did our job as reflected in our approval of the settlement, and that should be the end of it. They didn't take the occasion, they haven't yet, in our case, sort of articulated as a substantive defense of the settlement itself. They've essentially said, because we did it, that is enough, and we shouldn't have to talk about it anymore.
And what was the museum's position?
Same. That corporate members are not us, that the Attorney General is the only one who had any rights to complain about this, and the Attorney General told them it was okay.
And so where is it going now?
So the appeals court took the argument under advisement, so we will find out at some point their
And
decision
what you will find out is whether you can go forward.
is whether our lawsuit is reinstated or not. Yes.
All right, well, we will keep our listeners posted. Thank you, Nick, for the update.
Keep us posted. Thank
I shall
you.
do. Thank you very much.
And that's it for today's podcast. Please subscribe to us on iTunes or wherever you get your podcasts, and send us feedback at podcast@schlaw.com. And if you like what you hear, give us a 5-star rating. We are also featuring the original music of Chris Thompson. And finally, we want to thank our fabulous producer, Jackie Santos, for making us sound so good.
Until next time, I'm Katie Wilson-Milne.
And I'm Steve Schindler, bringing you the Art Law Podcast, a podcast exploring the places where art intersects with and interferes with the law.
And vice versa. The information provided in this podcast is not intended to be a source of legal advice. You should not consider the information provided to be an invitation for an attorney-client relationship, should not rely on the information as legal advice for any purpose, and should always seek the legal advice of competent counsel in the relevant jurisdiction.